Are we live? I think so. Hello, everybody. My name is Mark Jaffe. I'm a partner at Trademark Law. Today, we're going to be talking about trademarks for creative companies. And today, we're going to be talking about trademarks for creative companies and how you can use trademarks to better your business and to be more profitable, to be more efficient, and also to get rid of some of the pitfalls and some of the mistakes that people make when they're using their trademarks. The good news is that a lot of trademark law is fairly intuitive. You might already be doing the right things with your trademarks, but you might be making some big mistakes that you can avoid. For those of you watching the live stream, our CEO, Elissa, is part of this presentation as well. If you have any questions, just put them into your comment sections of your Facebook, of your YouTube, or Twitch. They will be read, and periodically throughout this presentation, I'll be answering some of your questions. Please understand there's no attorney-client relationship being built here. I am not your lawyer, unless I am your lawyer, in which case we can talk off this live stream. But I will not be answering questions to your specific situations, but rather general trademark related questions and questions about some of the things that I'm going to talk about today. As I said, trademark law is fairly intuitive. If you're a good business owner, if you have a really good brand, you might be doing a lot of the right things. Also good news, in about 10, 15 minutes into this presentation, I'm going to be telling you your most important takeaway. The most important thing you can remember from this presentation if you don't remember anything else at all. So stick around. Let's start with the beginning. What's a trademark? Well, a trademark is anything that you use to designate your goods or your services, anything that you market or anything that you sell, whatever you use to designate that and let the public know that it comes from you, that you are the source from it. That's a trademark. That trademark tells the consumers, the market, the rest of the world that what I'm looking at comes from one particular source, and that's you, if it's your trademark, and from nobody else. And it protects against their own confusion so that if a competitor uses a similar name or a similar logo on that product, they should be protected against that kind of confusion because it should come from that one particular source. We'll get into that a little bit more, but the point is the trademarks designate the source of the goods. And what can be a trademark? Well, pretty much anything can possibly be a trademark, pretty much anything, as long as it satisfies the criteria. The most common types of trademarks we know are words. Often they're very simple words. We stick them on a package. It says Snyder's, it says Nike, it says Starbucks, it says Apple. That's on top of the product. We know that that comes from one particular source, from that particular company that manufactures those goods or provides those services. You don't own the word for every single use. It's not a monopoly use. It's not a property right. It's just your trademark rights in connection with those particular goods. So you can even have a trademark on some very simple words. For instance, Tide is a trademark. If we put it on any type of a bottle like this, you know it's from one particular company and you know it's some type of cleaning product. The same thing with all. All is a trademark when we see it on products like these. We expect that any one of these is a cleaning product that comes from that same company. Trademark law doesn't require that we know who the parent company is, but we suspect that there is one. It doesn't cover all the uses of the word all. If there's a live concert and there's the band All, which also uses that name as a trademark, we know it's not related to these particular goods. So when can you use that same word and when can you not? We'll talk. The answer is it depends, but we'll talk a little bit more about it later. Chunky is a trademark for the candy bars. A slogan can sometimes be a trademark so long as the customer associates it with one particular good or service. This Bud's for you. That's a trademark. We associate it with the Budweiser beer. Budweiser, of course, it's its own trademark, and it's part of the Anheuser-Busch company, which is also on this label, so you know it's using it as a trademark. Budweiser's marketing was a little different for that because they established their rights first with commercials using the name, and at the point where you saw these commercials so much that you associated it with Budweiser, they developed their trademark rights. Logos can be trademarks as well. They're very common. When we see this on a product, we know it's a, if you're there by the screen, put it into, yes, yes, we always know that this is an Apple product. Apple is, of course, part of the Microsoft company, and Apple itself is a trademark. But when we see that, logo, when we see that Apple with a bite through it, we know it's an Apple product. And we don't, and if it's not an Apple product and it has that, we feel cheated. Trademark law gives the Microsoft company, who owns the Apple trademark, the right to go over after anybody who makes devices with the logo that's going to confuse customers or likely to confuse customers. That's one of the most famous logos right there. Even if I didn't have that, I think most of you would recognize that as a Starbucks logo. They put it on their shops. They put it on all their coffee products. They put it on the foods that they sell. They put it on cups like these to let you know it's a trademark for the coffee and also probably for the cups themselves. You'll notice there's an R in the circle on each of these cups. That's for a trademark that is registered with the United States Patent and Trademark Office. I'll explain what that means quite soon. If you're looking at this, you know it's a, put it in your comment section. Okay, this is an easy one, and it's good that's an easy one because that means the Nike company has one of the strongest logo trademarks there is. And it's simple and it's elegant, but it also works for them. They have more than one logo. This one has the Nike name in a stylized font plus the swoosh. Each of those is registered. That's why you see the R in a circle. We know all of these is a Nike product. Those are the words and the logos are the most common trademarks that we're going to experience. But trade dress can also be a trademark, function as a trademark. Trade dress means the shape of the product or its packaging. We know by the packaging, we know by the shape that it comes from one particular source. It's much harder to protect, it's harder to do, but it's possible. Coca-Cola has done it in a number of ways. For instance, this particular shape of the bottle. When we see that in the cooler in a refrigerator, we recognize that as a Coca-Cola product because they've used that particular shape for so long. Similarly, the label that you're looking at with the red color and the white script and the line underneath, that's such a recognizable trademark as this particular brand that when they did a marketing campaign like this, where they put other names into that, use the same script, use that same white line, use that same shade of red, you still recognize this as a Coca-Cola product. That's how good their branding is. Also terrific at branding. What's this? Put that in the comments.
Louboutin.
Yeah, this is usually the most popular shout out I get by this point. We recognize this as a Louboutin shoe. That's Christian Louboutin, and there's the trademark right there because there's that particular shade of red on the soles. This trademark in the red sole is so important that Louboutin had to fight this in court when someone else when they challenged a competitor that was making red shoes with a red sole, and they had a half win with it. The court upheld its trademark rights in the red sole of a shoe and this particular shade of red, but it also held that it's only a protectable trademark for Louboutin when it's this shade of red on the heel of a shoe and the rest of the shoe is not red, like what you're looking at here.
Question mark.
Yeah.
If a shoe if this shade of red was on the sole of a work boot or a tennis shoe, something that was completely different style, do you think that would hold?
The answer is it depends. As many trademark questions like this. Later, I'm going to be talking about what are the factors that it depends on. But what I'll be talking about the legal considerations, right? Whether or not consumers are be likely to confused because they see a shoe like that and they think it might be a Louboutin, because even if Louboutin doesn't make work boots, someone might see that and think they do. Those are I'll talk about the legal consideration, but there's a very practical consideration, which is Louboutin's going to come after you. And if you're thinking about manufacturing a shoe or a boot like that, is it worth it to you? Because it's worth everything to Louboutin to shut you down. And they will certainly spend more on their legal fees than they can get out of you on damages. They're so good with the branding of the red sole, by the way, that they get lots of people shouting them out. They get free advertising in the form of J-Lo songs and many other places. It's enough that we hear the term red soles, we think Louboutin. A candy in this silver wrapper that's wrapped around the candy in that particular shape with the white ribbon coming out of that, we recognize that as a Hershey's Kiss. It's a protectable trademark for the Hershey's company. Around my part of town in Berkeley, you can get these in a local store, and they call them Cheddar Whales, and they're cheese-flavored snack products that are shaped like whales. Why do they do that? Well, they're playing it safe because Pepperidge Farm protects the shape in its Goldfish cracker. It protects the name Goldfish and associated with cracker. So Pepperidge Farm is a trademark. Goldfish is a trademark for snack crackers, and also that particular shape of the fish. And it means a lot to Pepperidge Farm. They will pursue what they perceive to be any type of infringement. They even sued the Nickelodeon company when they manufactured this particular snack in connection with their Cat Dog TV series. It was a bunch of snacks and cheddar full of different things that dogs or cats might like bones and yarn or whatever, but one of them was a fish. And Pepperidge Farm argued, took them to court and argued, if people see that in a bowl, right? You may know when you buy them at the store that these aren't Goldfish crackers, but if people see that in a bowl on your counter, they might think it's Pepperidge Farm. They're likely to be confused, or it's going to dilute our brand. We're damaged. Does anyone know what this is? Put it in the comments.
And Hydraxes.
All right. Well, the good news is the people who said Hydrax, you're correct. This is a Hydrax cookie, and that is an Oreo cookie. Why can they look similar? Because the trade dress of the sandwich cookie itself is not protected. Long ago, one of them tried, it failed. I think Hydrax was actually first, which usually gives you more rights. But nevertheless, they sell sandwich cookies, and you can find even more other sandwich cookies. Chocolate cookie on the end, the cream in the middle. If you look more carefully, you'll see that there are specific designs in the cookie. Those designs are protected. And of course, the name Hydrax is protected, and so is Oreo for cookies specifically. Pocky, on the other hand, if you like Pocky sticks, as I do, they were also not very fortunate with enforcing the shape of the cookie itself. What they did was they sued one of their imitators, and you can see one in this picture I took in an Oakland store. And they said, we had trade dress rights in a cookie stick that's long and looks like it's dipped in chocolate. And they lost. They lost at a district court. They lost it in an appeals court. And as of right now, it's my understanding they are appealing to the Supreme Court of the United States. That's how important it is. But right now, they don't enjoy trademark protection for that particular stick, the way it looks like, although they still have trademark protection for the name Pocky.
Mark, we have a question here. Is there a reason that it's proving so difficult for Pocky?
Yeah, there are a number of reasons why trade dress is more difficult to protect. One of them is if they're functional. If we determine that there's a function for that particular item, we don't want to protect it by trademark, because functional or useful items are things we protect by patents, and patents have really short lives. Trademarks can be forever so long as you keep on using them. So one of the arguments that it will typically have is it's functional. Others that it will be ornamental. We don't really see a particular source when we see this. We just see this as something that we like, that's pretty to look at. So when you're trying to protect your trade dress, you have to put a little more work into it. Now that I've mentioned it, you can see some of the advertising that some brands do to make sure that that you associate it with. It particularly happens with the colors. UPS emphasizes that it's brown, and the sweet and low packets say look for the pink. These are the things they want to influence consumers and let you know to always think their particular brand. It also helps them when they get to court. Sometimes sound can be trademarks. And one of the ones that I've worked with is the Mr. Softy song. If you're from the East Coast, you'd recognize that it goes. The reason it's a trademark, the reason the sound can be a trademark is because when you're in your house and it's the summertime and you hear that song, you know that there's a Mr. Softy truck coming down the street, and you expect it to be a Mr. Softy truck and not something else. The sound that you hear when you turn on Windows, when you turn on your computer, some of the rings associated with your cell phone, some of the sound effect sounds that you hear right before the start of a movie. Those are all examples of sounds being used as trademarks. It's much less common, it's a little more unusual, but it's possible. Mr. Softy vigorously protects its trademark rights. That includes the song, which it uses for his ice cream trucks all over the Northeast, and in particular New York, plus everything that you see here is part of the trade dress of the truck. That's the blue trim on the bottom, the creepy ice cream head, and everything else that you see all together. People expect to see a Mr. Softy truck. And it licenses the use of all these trademarks to other ice cream trucks. They get all the ice cream, they get ingredients, and they also get to use those trademarks. And when the contract is expired and they no longer have the rights to use any of these, and they still go out and call themselves Mr. Softy, that's when they're going to be on the end of a lawsuit, and quite a detrimental one for them.
Mark,
yeah.
I have an excellent comment here that Harley tried to file a sound trademark for the sound of their vehicle, of their motorcycles.
Yes, that did happen, and I don't think they were successful. I think that was, but I'm not certain. If they did, if they were able to do it for certain purposes. But yeah, I have to look that up. I do remember they're aiming to do that. Yeah. Usually what happens is you're using it for a long time. You really want to create that consumer association before they go ahead and do it. It was a surprise. The most unusual one I've heard of recently is Pitbull registered a trademark in the yell he does on records. So that is a registered trademark in connection with a sound recording. That was kind of surprised. That's highly unusual. Moving on to more unusual trademarks, sometimes a color can be a trademark. It will be specific to the goods you're using them with, and particularly that particular shade. So Tiffany and Company successfully protected and registered this light blue color for the gift boxes. It doesn't mean you can't use it for anything. It doesn't mean you have to toss out your markers that look like this, but it does mean that consumers, that people shopping, they see this particular box in this particular shade with perhaps with the white bow, and they think they're getting a Tiffany. And if you were going to give your significant other a box and it looked like this and they open it up and it's not a Tiffany, they might be disappointed.
Mark, I have another question from Facebook. Are there other musical artists that have trademarked their sound, or is that unusual?
What Pitbull did, I think, was highly unusual, because typically your recordings are protected by copyright. You don't necessarily need trademark rights in them. And if you tried to assert trademark rights, they're not likely to be recognized, even if you have a slogan you're associated with. It'll be different, as we'll talk about, if you take that slogan and you put them on goods, and then you can say, this is my line of t-shirts, right? LL Cool J has recently done that with Don't Call It a Comeback. Steve Miller Band did that with Some Call Me Maurice. Taylor Swift, most infamously, with This Sick Beat. The reason that they were able to protect those as trademarks is not just because they set them on a song, but because they labeled those on goods and that they sold them. What made Pitbulls unique was that it's a trademark for the recordings themselves. And I have yet to this date know of any producers with their producer tags, like Khaled or Jules or so many of them using producer tags, have tried to claim them as trademarks, but I really wouldn't be surprised to see that. This is one of the most unusual. This is rare. This is extremely rare. Play-Doh got trademark protection very recently, got a trademark registration for that smell of its Play-Doh. So that's the one that keeps kids from eating the Play-Doh, or perhaps is attractive to some kids when they do eat it. But Play-Doh, which of course is itself is a trademark for clay, they now have trademark protection for that smell. You cannot usually get a trademark protection for a scent. If the scent is the point, like a cologne, it's not going to happen. Okay, I know you know what this is, and here's where I get to the most important takeaway for this entire presentation, which is the most important thing you can do to keep your trademark protected and your trademark strong is to use your trademark. Use that trademark for your goods and services. Create that consumer association. Make sure that consumers, the market that you want or the broader market, sees that and knows that it's from you. That's the most important thing you can do with your trademarks. It's even more important. It's your trademark rights, whether your trademarks are registered or not in the United States. Different rules in other countries, and that's when to keep your trademark strong. I'll talk about registration. It's really important. But again, your most important takeaway is use your trademarks. And if you forget everything else in this presentation, remember that. Louis Vuitton doesn't see trademarks as just something it does, something it registered. It's the entire brand. It's the value of their brand. It's why when they go after and they want to bring lawsuits, they will bring all their guns. They don't necessarily want your money, that they do want to shut you down. On the right, you'll see what they call the Murakami design. They typically will go after manufacturers of any handbags making any type of similar designs. They're so aggressive about it, they will often initiate lawsuits that will lose. But not everybody wants to fight them. Louis Vuitton, of course, the name, also a trademark, as is that LV symbol. Questions?
I don't have any new ones that popped up quite yet.
Okay, let's talk about registration. This is not going to be a presentation primarily about registration, but registration is important. And what I'm going to be talking about, I will remind you, are specifically United States rules, which is we have a trademark office. It's the USPTO. The PTO does not give you a trademark. Remember, trademark rights derive from use. You might have them if they're not registered, but the trademark office will register your trademark and recognize your trademark rights, right? That's why I avoid saying trademarking as a verb, because trademarking can mean more than one thing. It can mean you're asserting your rights, or that you have your rights, or that it's registered. And the registration will be for the particular goods or services that you registered for, not the use of your trademark for absolutely everything, but only the goods or services for which you registered for, and you're using it for, and the trademark office recognizes that. And you get some advantages out of that. You get the presumption of the validity of your trademark. In fact, some of those presumptions will become conclusive after you renew in 5 years, which conclusive meaning some of the things I'm going to be talking about in this very next segment, people won't be able to challenge. They won't be able to challenge it. Registration allows you to use the registration symbol, which is the R in the circle. Do not use that unless your trademark is registered for the goods or services you're using it with.
Mark,
yeah.
I have two questions that popped up. One says, I know people who use the TM or R without registering. Is that okay?
Well, the R is not. I'm not giving specific legal advice. to the people that you know. But if you're using the R in the circle and it's not registered, let's just say I said take them down now. That's fraud. Trademark law considers that fraud. It's fraud on the consumers. It's not the type of fraud where there's usually criminal prosecution, but you're taking a huge risk. Don't do it. The TM, however, does not require that your trademark is registered. In fact, there aren't any laws governing the TM. So TM is sometimes what brands do to show they're exercising their trademark rights and they believe what you're using is a trademark. It's often done when you apply to register for a trademark and you're waiting for the registration, which could take 9 months, could take a year, it can take a long time. So, and usually, most often, you want to keep on doing what you're doing. So you use that TM symbol. You might also see the SM symbol. SM stands for service mark. Some companies use that for their trademarks when they're in connection with services as opposed to trademarks like banking services or online software services. Whether or not you use a TM or an SM is up to you. There are no laws governing the TM or the SM.
The second question I got here on YouTube, do you need a lawyer to register or can you do it on your own?
Good question. You're not required to use a lawyer. You're not required to use a lawyer unless you are registering in the United States and you're outside of the United States. There are new rules that you need an American representative. There are many reasons you might want a lawyer. It's a complicated process. You don't want to make mistakes that you later have to clean up that you could have avoided. You want to do a lot of the damage control. Also, what we do is we don't just register your trademark, we craft your whole trademark and branding strategy around it, which is really critical. But there are no rules that you have to be a trademark lawyer or even a lawyer to start the application process yourself. And many people do it without a lawyer. There are also third-party services that aren't lawyers. The ones I know of aren't very good at all. They're just not worth it. They're not giving you any added. They're not giving you any added value. So good questions. That registered trademark can give you potentially more damages if you do bring a lawsuit. You might not want to sue, but when you're sending a cease and demand letter, when you're telling somebody else to cease and desist using something because they're infringing your trademark, knowing that it's registered shows them you really mean business and that the consequences can be much greater. All right. So thinking about a name for your company or a name for your good or a name for the service that you put out. This is where you have to think a bit about what trademark law does and what kind of trademarks are considered strong and highly protectable and what are not, beyond just infringing other trademarks. We think of trademarks in words as generic, descriptive, suggestive, arbitrary, fanciful. I'll go over all of them, but the key things you need to know is good trademarks are inherently distinctive. They're inherently distinctive when people look at them and they know it's a trademark, right? At the lowest end of the spectrum is generic. If you want to market a soda and put the word soda on it, if you want to market a beer and put the word beer on it, if you want to have a bag of strawberries and sell the strawberries and it says strawberries on it, trademark law is not going to stop you, but it's not going to give you any trademark protection for that at all. None. These are the generic words for the term. So they're highly unadvised. You will fail. And in fact, light beer is also considered to be generic, which is why you're going to see different manufacturers can put light beer on there, but it's not going to be enough for trademark protection. If you have a pizzeria and you call it pizzeria, it's generic, it won't be protected. If you market a pizza and call it pizza, it's not protected. Similarly, because one of the ones you're looking at attempted to do it, you won't get trademark protection for brick oven pizza if you have a brick oven pizza. That's generic. So when I say they're the lowest form of trademark, I don't really mean that at all. They're not trademarks at all. They're not protected. Descriptive is a little higher up. Descriptive is a word or phrase that describes what your product does. American Apparel, it's clothing from America. I just passed by the Bank of America on the way to here. There's a Continental Airlines. These are descriptive trademarks. All they do is describe what you do. This is considered to be the lowest form of protection. The only way you can get it registered is if you have to prove to the trademark office, or if you're suing, you have to prove to a court that consumers don't just think, oh, this is what you do. You're just an airline that flies continentally. No, you have to show them that you've used it over time before it's registered or fully registered. And consumers now look at an American Apparel product and say, this is one particular brand. They now see a Bank of America as a Bank of America. It's harder to protect. It's more expensive. It occurs complications because there are going to be so many uses, non-trademark uses that you're going to have to fight against. Trademark lawyers typically will recommend against it. But as you can see from the products, it did work out for some of these. Bloomingdale's very recently registered the little brown bag as a trademark for these bags. Now, if you've gone to the store, you've known they've been packaging them stuff in those for a long time. So why did they only recently get a registration? Because it's very descriptive. It's a bag and it's brown and it's little. It takes extra work to convince a court, to convince the trademark office, to convince anyone really that these are protectable trademarks. So we recommend against that. It's a greater investment that you really need. A step up is suggestive. A suggestive trademark could be about what your good is or what your service is, but unlike American Apparel, it's not immediately obvious to the consumer what it is. They would have to do a little more brain work. They would have to have it explained to them. Movie Buff was found to be a suggestive trademark. It was a service for watching films for movie buffs. This is my favorite. I saw it on the streets of Brooklyn one day and snapped a picture of the truck. So it was absolutely brilliant. A moving company called Schleppers. It does kind of say what they do. They do schlep your stuff, but if you just saw it, but if you otherwise didn't know and didn't see everything together and just said it was a company called Schleppers, you wouldn't necessarily know. The water cooler in my office is made by a company called Quench. Pinterest was held to be a suggestive trademark. It's a blend of the word pin for marking certain stuff online and the words interest. Survivor for survivor, combination of surf and survivor, also recognized as being suggestive. A trademark colleague of mine took a picture of this. It's a play on words, Locksmith Hair Studio, which is kind of cool, but also suggestive for hair services. Now we move up to the more highly protected. Arbitrary trademarks are when that trademark doesn't have to do with the good or services that you're selling. So if you see Apple on a computer, it's a strong trademark because Apple has nothing to do with computers. If you put a bag on Apple, on a bag of apples, it's generic. It'll never be your trademark. But they did it for computers, it's protected. A store called Target, arbitrary. Notice also that they have a very simple logo, but a highly recognizable one. Then we get to the highest end. Trademark law calls these fanciful trademarks. They're quite simply words that they made up. Xerox for copy machines. Exxon for gas. Made up words. And there are a lot of them. As you go around, you'll see that there are more of them. They're considered to be the highest form of protection for your mark because people only see it as your particular source. They're inherently distinctive. And even them, there are pitfalls, which I'm going to mention in a bit. So what do you need to know? There's inherently distinctive trademarks where people know that they're trademarks, and that there are trademarks that are descriptive, which require you to show secondary meaning. Secondary meaning means you prove that consumers associate that particular trademark with your goods. Generic, light beer, never going to be protected. Descriptive, American Apparel, can be protected, but it took a lot of effort on their part. Questions? Okay.
No new ones, but I do have a comment that popped up, and that was a comment that said one of the common fire truck sirens is trademarked.
There's a trademark for a fire truck siren? I'd be highly surprised. I'd be highly surprised. I'm not saying it's impossible, but I'd be highly surprised because that performs a function. It might need to be protected for other reasons, because the public has to be protected and know that a fire truck is a fire truck and an emergency vehicle and not something else. So there might be other laws protecting it, but I'm not sure about the fire truck trademark. I'll look that up. Thanks. Okay. Remember what I said about Xerox being a highly protected trademark because it's fanciful, but it runs into problems. It's because many people used to use Xerox to mean any photocopier or the act of photocopying or the photocopy itself. Can you Xerox something for me? Can you get me a Xerox? Can you use the Xerox over there, even though it wasn't a Xerox brand copy machine? Xerox hated that because that's a generic use. And if there's enough generic use of that term, you can lose your trademark rights entirely. It's not an easy thing to happen, but it is something that has most definitely happened. Story. Long ago, Bayer invented a drug for pain relief, which I have a hard time pronouncing the real name, but it was a pain relief. You can see it in the middle of this package, and they got a patent on it. My presentation is not a patent presentation. Patents are completely different, but you can get patents on drugs, and they last only a short term. So for that short term, they marketed it, and they called it aspirin as their trademark. And then when the patent was up, back then it was 17 years, today it's 20, other people started making that same drug, which they're allowed to do under FDA regulations. But one of them decided to call it aspirin. And Bayer sued, said, you can't use aspirin. That's our trademark. And the court found that aspirin had gone generic as the name of the drug. People used aspirin not as a trademark, but to refer to the drug at all. And Bayer had even messed up at the time because their bottle said Bayer, tablets of aspirin, as if aspirin was the thing, was the drug itself and not the brand. So they lost it, and that was long ago. Now trademark law won't prohibit you from calling something aspirin. Of course, we do have an FDA. Don't use it if what you have isn't the actual formula. Some trademark lawyers call this genericide. I think it's kind of an ugly word, but nevertheless, there's a generic graveyard, and there's so many of them. Zipper, elevator. You all know what this is, right? It's a trampoline. All of these can be trampolines because trampoline used to be a trademark, like zipper used to be a trademark, and elevator used to be a trademark, and now they've become generic. They're generic words for the thing, and everybody else is free to use it for that same thing. However, a lot of them, even if we use them generically, are protected.
Mark?
Yeah.
There's a question here. Is it harder with the courts to genericize now, or are brands smarter?
Oh, I think it's much harder now, and brands are smarter. Absolutely, absolutely. And I'll show you some of the techniques that they're using. Absolutely. First of all, I think courts are reluctant to do it. Absolutely reluctant to get it. You bring it there, and they say, okay, do I want to destroy somebody's brand? Somebody tried it with Google. Somebody tried to take Google to court and say Google's a generic term for internet searching. Well, we do sometimes use Google as a generic term for internet searching, but everybody knows Google's a brand. Everybody knows Google's a trademark. Everybody knows there's a Google search engine. And I don't think courts want to do it that easily. So it doesn't happen that much anymore. Not in courts. Of course, you know, it's much harder to police how people actually talk in the real world. So you're going to see a lot of techniques that we'll talk about that brands use. But if you're happy that people use your trademark generically, stop being happy about it and do something about it. Kleenex did, right? Kleenex, this is generational. I don't think it's common much anymore, but so many people used to use Kleenex to mean tissues. And since Kleenex is a brand, particularly the Johnson & Johnson brand of tissues, they don't want you to do that. It's all, for them, the logo you see on the box is made bigger at top. They're going to put that logo on there. They're going to have the R in the circle, and the box is going to say, if you have one near, this is what it says. It doesn't say box of Kleenex. It says Kleenex brand tissue. They want you to know it's only a Kleenex. It's a Kleenex brand tissue. It's right there. It's going to be on every box you see. Hopefully that works with the public as far as the company is concerned, but it's also something that they can show the court. Look, we're doing our best not to keep it generic. Does anybody know what this is?
It's a frisbee.
Yeah, lots of people think it's a frisbee. Well, it's not. It's a flying disc of some kind, as anybody's allowed to make that particular flying disc. But Frisbee's a Whammo brand. As far as Whammo is concerned, it owns the trademark to Frisbee, and it's been registered for years. Whammo doesn't want you to ever use the word Frisbee generically for a flying disc. So you'll notice the disc that I showed before, it doesn't say Frisbee on it. Because if it did, Whammo's going to try to take them down. That piece of plastic doesn't cost a lot. It's not worth it for them to fight Whammo. That's a lot of work for Whammo's part, though, right? Yeah, they can't come to your barbecue. They can't go to the beach and start instructing people how to talk. So it's a lot of work for them, but it means a lot to them. And Whammo's branding people and Whammo's lawyers are really busy with this kind of thing. Why? Because not only do they own a trademark rights in Frisbee, but they assert trademark rights in hula hoop and slip and slide. All these things where you probably, just like you did now, use for a product that isn't a Whammo product. And remember, this is Whammo's responsibility. What are you supposed to call a hoop that looks like a hula hoop and isn't a Whammo brand hula hoop? It's Whammo's problem.
Mark, I got two questions that came in here. One just as a comment that says, what about Ultimate Frisbee?
It's no longer called Ultimate Frisbee. Have you noticed? It used to be called Ultimate Frisbee back when I played in high school. Now they just call it Ultimate. Great question.
Great question. Never heard that.
Yeah. Now if you notice, as far as any time that I see it on TV or any time that I know of a school has competitions, they're calling it Ultimate. Long ago, they called it Ultimate Frisbee. And of course, when I played, it was always with a Whammo, but we knew it was a trademark. Somewhere along the line, the word Frisbee was dropped from it. I assume that was pressure from Whammo, but I'm not really sure.
Similarly, I would think that Ultimate would be hard for the league to trademark if there's a league.
Possibly.
The other question is, how can brands prevent their marks from being generic?
Well, one of them is to do what we saw with Kleenex, right? You don't say box of Kleenex. You always say Kleenex brand tissues, right? You always make sure that you know what that thing is. This is a Goldfish cracker. This is a Kleenex tissue. This is a Xerox photocopier, right? You emphasize that, and you try to get people to think about it that way and talk about it that way. Google, it used to be on their terms of use, right? They can't demand that you do it, but they're saying, please don't say I Googled this. Please say I did it. I conducted an internet search with the Google brand search engine. I think it's working well for Google. It's been a little harder for Adobe though. This is from Adobe's terms of use. If you can't see it, it says, please don't say I Photoshop an image. Please don't say this image is Photoshopped. Photoshop is our Adobe trademark. Please don't do it. That they're kind of begging, but this is one of the things they have to do because Photoshop is a particular software. Not, as far as they're concerned, a generic word for altering a picture. I think the more modern sound equivalent is we use Auto-Tune or AstroTurf, which all of which tend to often have negative connotations, but are also used generically when they're trademarks. Now that I mentioned it, you're going to see a lot more advertising out in the world that does this kind of thing. A lot of them are pleased. They're desperate. They're from the Zipper. They're from the Xerox company. Said, please don't do to us what they did to Zipper. Please say Xerox brand photo company. I think some of them are kind of desperate. They may or may not be effective, but Chrysler did a much better job. Chrysler did a much better job with its ad than many of the others, right? This is a Jeep. Jeep is a trademark. So instead of just telling you, please don't say Jeep for any type of large vehicle, please only do it if it's the actual Chrysler Jeep. But they didn't do that. They put this ad out to let you know why the Jeep is better than any other vehicle. Excellent advertising on my part. Maybe sometime later in the day, you can find the Velcro guys actually made music videos. I'm not putting them in here. I'm not very fond of it myself, but they've been pretty popular. They don't want you to say Velcro to mean the fastener. They want you to say hook and loop for the fastener as the generic term, and recognize that Velcro is a brand name. It's a trademark. I don't know if it's working with the general public, but when you see items like this for sale on Amazon or any other place that sells them, notice they're doing what Velcro wants them to do. They're calling them Velcro trademark, brand, and either hook and loop or brand fasteners. So be smart with that. Think about how you're projecting your trademarks to the world, and don't lose that. It's hard to lose it, but it's kind of catastrophic and highly disappointing to lose it the way some trademarks does. And keep an eye out for the strategies that you'll see. Questions before we talk about likelihood of confusion?
None popped up on that one.
Excellent. Thanks for the questions, everyone. Keep them coming. You can. Alyssa's looking at all of them. You can put them in any of the comments, the YouTube, the Twitch, or the Facebook. These have been great questions, and they help, and they really help us make a good presentation. Okay. So, what happens when one trademark is similar to another trademark? What happens when you want to go after somebody who's using your same trademark or a similar one, or somebody comes after you? What if somebody sues you, or you need to sue somebody else for trademark infringement? Or what if you're applying to register a trademark and someone else opposes the registration because it's similar to yours, or the trademark office says it's similar to a registration? Well, the answer is always depends, and I'll talk a little bit about what it depends on. The key words you need to know are likelihood of confusion. Would a consumer be likely to confuse one good for the other because of that same or similar trademark? And there are a number of factors that we determine to decide whether or not there's likelihood of confusion. They can be called the Pizza Hut factors, the sleek craft factors, the Polaroid factors, depending on where the lawsuit is. But they tend to be very similar, very, very similar factors. And again, usually intuitive. One of the most important, strength of the mark. The stronger that you have the mark when you're enforcing against somebody else's, the better case that you have. We measure strength in two different ways. One could be what I talked about at arbitrary and fanciful trademarks. They're the highest level of protection. They're considered strong. Descriptive are considered less strong. Pinterest, you may recall, is in the middle. It's suggestive. So it's not the strongest trademark when you measure it that way, but they also show to court, we have millions and millions of users. People pin things every day, and they know they're using the Pinterest app. They click on that Pinterest app on the phone. So often there are surveys. What do you associate Pinterest with? And they show the results of the surveys to the court. So from a consumer association standpoint, considered to be highly strong. If the services or goods that you're putting out are similar, using that same trademark, they're more likely to be confusing, right? I mentioned how the all detergent and the all rock band, not likely to be confusing. Apple dry cleaners, you probably don't think it's part of the Microsoft company. But alcoholic beverages are typically held to be similar enough services, even when it's a beer and a vodka. And that's what happened in this lawsuit involving Mastermind Beer and Mastermind Vodka. Not similar, Tough Love, which was actual support services similar to the Tough Love. They sued VH1 for a TV show called Tough Love. Those are held not to be infringing, and one of the key factors was that the television program is very different than actual Tough Love psychology services. And then again, one of the most important, the marks themselves, the trademarks. Are they similar enough? Keep in mind that the similarity of the trademarks are best considered when you see them on the good or on the service and how they are in the marketplace. If I showed you these logos that look like a lipstick kiss and said they're both associated with a vodka, are they likely to be confused? You might say yes, but if you saw the bottles, that's one, that's the other. If you look at just the kiss, they may look very similar. and it's the same good. But once you put them on a bottle and you look at everything together, much less likely to be confused.
Hey,
What
Mark,
about hot? Yeah.
a question came in that says, do you need a lawyer if you receive a cease and desist?
Okay. Well, if you're served a cease and desist,
It just says
is that the
receive.
question? If you get a demand letter, I
And
would
you
highly
comment,
recommend.
it says via email or letter. So
Yeah.
I'm thinking that you're not served, but
Yeah. Do you need one? I would highly recommend you're getting a lawyer. Even just to respond, you're going to want a lawyer just to know what kind of strategy you should take now. Are they right? Are they bluffing? Should I tell them to go screw themselves? Do I say we have our rights first before you, and we can't be infringing, you might be infringing on us? Or even if you want to roll over, even if you want to say, oops, we agree not to do it anymore, your safest thing is to have a lawyer and negotiate an actual written agreement. Sometimes the agreement is, if you're different goods or you're different services, you do what's called a coexistence agreement. You really need a lawyer for that, in my view. Coexistence agreement says, we make these things and use this trademark. You make that stuff with that trademark. We agree not to make that stuff with the trademark, and you agree not to make what we do with that same trademark. And we agree never to, as long as we stay within the rules we have in this agreement, we're not going to sue each other and we're not going to challenge anybody else's uses. Those have to be done very carefully. They are really more often than we realize the way trademark disputes are resolved, right? Otherwise, as you see in this graphic, you're going to a jury. Juries are kind of crapshoots, just like the marketplace, right? Hot Wheels and hot rigs, court decided for these toy cars, I, the judge, cannot decide whether these are similar enough trademarks for toy cars. We're going to leave that to a jury. On the other hand, Stark and Stark Raving for wines were held not to be similarly confusing, different enough. Why? Again, look at the context. That's the Stark wine. That's the Stark Raving wine. Once you see the bottles, even though it's the same word there, you're not likely to be confused.
hey, Mark,
Yeah.
are jury trials common for trademarks?
What's that?
Are jury trials common for trademarks?
Compared to the number of actual trademark disputes there are, no. Many of them are resolved by judges on what's called a motion for summary judgment, where the judge makes its own decision in place of a jury. But without getting into the legal mechanisms, the judges only really should be doing that when they're absolutely certain that no jury could decide any other way. And then even if it gets right to the end of the jury, most parties don't know if they want to actually go through with it. So yes, jury trials happen. They can have very huge damages. When Adidas has, for instance, has been able to sue over its 3-stripe trademark. They sued Payless and got a jury verdict of over $200 million for lookalike shoes. A judge knocked that down, but sometimes you can see what kind of things are at stake when you go to a jury. And not everybody wants to take the chances if these things can be resolved. Right? You'd think juries might be in the best position to determine likelihood of confusion because they're regular people, right? But it's not the most common thing to happen in a trademark dispute. Just like in most litigation, doesn't get to trial. It doesn't happen, and it's fun stuff. Moving on, some other factors. I already talked about the most important factors, but what about actual confusion? Do you have to show that you actually have to go to court or go to the trademark office and show that people actually confuse the trademarks? The answer is no. It's not required that you show evidence of actual confusion because the standard is likelihood of confusion. It's not required, but sometimes it could be helpful. Sometimes. A band called Revolution, you can see that it's the word revolution, but with a B instead of the V. They decided to sue Pitbull, here he is again, because he named his record Revolution also with the B. And they used Facebook comments on their band webpage to show that their fans were confused. And some of the comments were, "Wow, are you doing a record with Pitbull? That's really cool. Good for you. How can I go? When can I go? Oh man," or "That's whack." But whatever, they thought they thought that they were actually doing something with Pitbull. That's evidence of actual confusion. They were confused because it wasn't true. However, there were other comments that said, "Pitbull's ripping you off. Screw that guy. How can he do this to you? You had your name first." Well, that's not evidence of actual confusion. That's evidence that they weren't confused. So that was less important in a trademark analysis. If people think you're ripping somebody off, but they're mad, that won't always help you. And it would be different if your trademark was very famous, in which case you can argue that your trademarks were diluted. That's a little bit beyond what we're going to do today, but think about that as well when you're going after famous brands. Courts will also take into account the degree of care exercised by purchasers. You go out to buy a car, you're going to put a lot of work into it first. You're not likely to buy the wrong car. More consumer care. But everything that you see here, the candy bars, the gum, the lighter, those are considered impulse purchase. You see that on the aisle of a supermarket, your kid's crying, you buy it, you barely think about it. Low degree of care. It factors into a greater likelihood of confusion. Single-serve beverages are generally held to be a low degree of care, even if they're fancy, like an expensive pomegranate juice or a craft beer. All of these, the general rule is that there's a low degree of care. Some courts don't call it degree of care, they call it sophistication of consumers. I prefer the phrase degree of care because the issue isn't the consumer themselves, it's how much care that they use. The same person will always take more care into purchasing a vehicle than they will a packet of gum. It's less about their own sophistication than the work that they put into it. And that's, in a nutshell, is likelihood of confusion. I said we'll touch only a little bit on registration, and as we go on, there's going to be other live streams where we're going to talk about different issues. But one thing you got to know about applying to register your trademark, and as I said, you may already have trademark rights based on your use, is first you want to do a search. You want to do a clearance search at the minimum with the USPTO. It has a database. It's called TEST. You can look up that trademark and many other trademarks. The search functions are kind of confusing. If you're doing it for the first time, it's going to take you a while to get used to it. And there are lots of nuances that might miss you by, which is why we often use third-party services that do the search and give us the results. But you're going to want to know now, before you go any further, if you're going to run into problems with potentially conflicting trademarks. You apply either on a use basis or an intent to use. You're either saying, I am using this trademark right now, and this is when I claim to be using it for these goods, or I intend to use it. I have a bona fide intent to use these in connection with these particular goods and services, and you submit the application for that. I would recommend you only do it when we only work with companies that have a real business plan. Right. The standard, as far as the USPTO is concerned, is bona fide intent to use. I like to see that you've really done something to take those steps, so that you're not blowing your money away on a good idea you have that you're not ready to follow through on. Also, there are a lot of ones where people just don't have a bona fide intent to use. They think they can snatch rights just by filing something. But worst case scenario, that's fraud. The best case scenario is literally nothing happens of it except you wasted your USPTO fees. You designate the goods and services. You will only get the registration for the goods and services you're ultimately using them for. You show proof of that, which is the specimen of use, and that's something that shows that trademark is on this particular good. If it's a beer, great. You put that logo on the beer. You show the beer as it's being sold. If it's a service, it's a little more tricky because you can't affix it. So you have to be more careful, and you have to be more creative, which you can do particularly when it's online services. Trademark examiner reviews it. They go over all the potential problems. Often they're very small problems. Some of them they're huge ones, like the likelihood of confusion with another registered trademark. And if you pass all those hurdles, it gets published for opposition. And during that period, anybody who wants to oppose it, often because they think it's going to be likely confused with their own, can oppose, which can be a highly expensive process for which many parties decide to resolve on their own. This process can take a long time. It used to be, I would say, the quickest it goes, if everything goes smoothly, is about 7-8 months from the time you file the application. Today, it's much longer than that. There's been a glut of applications to the USPTO that's dragging it down, and it's been very slow. It's a new development just in the last few months. I want to clarify, this is really important. I know I got people outside the United States on this, and you might want to seek trademark rights outside the United States. There's mechanisms to do it. Most other countries give priority based on registration, and the United States gives priority of trademark rights based on your use. So we do it a little differently than most other countries, and you have to understand that.
Mark, there's 2 questions here.
Yeah.
The first is, could you register a trademark for a product you haven't brought to market yet? That from
You can start the application process as an intent to use, and it's often very advantageous to want to do it that way. But if you're not bringing it to market at the end of when you've cleared all the hurdles, when it's gone through the opposition period and no one's opposed and you're ready, they'll send you a notice of allowance. It will not be registered until you submit to the trademark office, I am using it for these goods and services, and here's a specimen of use. Here's something that shows it. So you won't get the registration.
And the second question is there a way to keep the costs lower when hiring an attorney for trademarks? Like, can I do some of the work?
You can. It's really up to you and what's within your budget. As I said, we typically don't take people with really solid business plans that are investing a lot of money elsewhere. Your trademark budget shouldn't be half of the budget that you do for things. You really need a budget for the awesome things that you do. So think of it in terms of your budget and what you want out of it. Limit the amount of goods and services you're going to register it for, because goods and services are divided into different classes, and you'll have to look them up. So if you're registering for T-shirts, but you're also making toys, those are going to be different classes. You're going to pay a different fee for each of them. You may decide, well, I'm only going to start with one for now, the one that really means something to me. If they are goods that are within the same class, you won't be paying extra, like T-shirts and hoodies and various clothing items are always going to be within the same class. Even still, yeah.
Sorry. It looks like there's a follow-up. Is it easier to get a trademark in one class if you already have one in another?
Yes. Excellent question. In fact, let's say you've already got a registration for one. You're going to let the trademark office know you have that. If the examiner comes back with your new application and says this is merely descriptive, for instance, and we're going to refuse it until you prove us otherwise, one of the ways you can do that is by showing that you already have a registration for a particular good and service. So yes, absolutely. Another thing I recommend is if you're applying on an intent to use basis, don't get too greedy. Don't get too ahead of yourself. There's the things you know that really mean a lot to you that you're working to market. Stick with that. Don't say, but maybe I want to do this. Maybe I want to do this. Let's add this. Let's add that. It's going to be more expensive for you. It's also going to create a lot more problems for you if you don't wind up marketing those goods or services. As I said, the USPTO will ask for a specimen of use, and this shows your trademark on your particular good or service. If you have a beer, you put the logo on the beer, you're selling it. If you have a blog, you put that trademark, the name or the logo on top of the blog, you take a screen cap of the website, you submit it to the trademark office, you tell them what the URL is. If you're manufacturing phones or a phone case, you put that logo on the phone case. That's the best way to sue the trademark office. It's not always hard, but it can be tricky, particularly with clothing. Lizzo was so excited that that the term 100% that bitch came associated with her because of her hit song Truth Hurts, that she decided to register for trademarks in a number of services. Most of them, she didn't really have a hitch. She didn't really have any problems. She registered for sound recordings. She registered, I think, for live performances, maybe a couple of other goods. It was this T-shirt that held her up. Remember, trademark law isn't copyright law. It's not really concerned with the fact that she didn't originally write that line. It's more about the fact that she's associated with it. You think Lizzo. The problem with this T-shirt, from that particular examiner's perspective, is they saw this was what they called this an ornamental use. They said people don't look at this and see a product. People don't look at this and see 100% that bitch is the brand that it manufactures that T-shirt. They think you're going out and you're just telling everybody you're 100% that bitch, and it wouldn't register looking for that. Not a huge dilemma for her. What she did was she converted it to an intent to use, and she's going to go back and give them a specimen that examiner will approve of. Something that shows this looks like the brand, the product, the manufacturer. What Ariana Grande did right here. Right, she put her name, which she registered as a trademark for shirts, on the label itself, where we typically consider the brand name to appear, and then it's not merely ornamental. You never know what examiner you're going to get. There are many of them. They tend to have their own views about things, and sometimes they're not very consistent. On the right, that's the 100% that bitch T-shirt I told you about. An examiner refused it. On the left, that's the T-shirt that Nike used 30 years ago when it applied to register its trademark for Just Do It for T-shirts. At that time, it was relatively new, but associated with Nike based on the commercials. And that T-shirt was found to be an acceptable specimen for the Just Do It name for T-shirts. You may be looking at this and say, why is that so much different? Why is Just Do It on the left so much different than 100% on the right? I mean, I have my theories, but they're not really theories compatible with trademark law. Sometimes you're unfortunate, and you can either fight or you can go back to the drawing board, which is what she did.
Mark, I have another comment from Twitch. It says, so is her name the brand name? Would someone else with a similar name be able to use their name on their own products, or would they be violating the trademark?
Oh, man. Yeah, that's happened. You mean somebody actually using their own name, right? Like, yeah, it's happened, and sometimes they've been sued. It's kind of a bummer. But if you've established really strong rights, then it does tend to make sense. So there have been situations where people had orders against them from using their own names for particular products. If your name Ben and your friend is named Jerry and you guys are thinking to make ice cream and that's your name, and you call the ice cream Ben and Jerry's, they're going to sue you. I think they're going to win and if you make it Jerry and Ben, they probably are too. So the answer is it's possible. It is possible that you can be stopped from using your name for specific goods and services that are associated with somebody else's. You will also be prohibited from registering names if they're known to be recognized to be someone else's name and you don't have the consent of that person. The trademark office won't register those. Okay, some of the fun developing and new issues that we're seeing in trademark law, and some of the things you can do and some of the things you can't do. What if you want to have a trademark and register it and there's profanity in part of your trademark? Up until a few years ago, you couldn't do that because the trademark laws, which are called the Lanham Act, said you couldn't register a trademark if it was immoral or scandalous, or if it's disparaging to other persons. Immoral and scandalous was taken to mean various curse words, and disparaging to other persons prohibited you from registering trademarks with ethnic slurs. And a rock band, I'll make a very long story short, a rock band called the Slants, a rock band made up of Asian Americans who wanted to reclaim the slur for themselves, took it all the way to the Supreme Court. Remember, refusal of a trademark registration doesn't mean you can't use the trademark, but it means you don't get the trademark protection. You don't get the registration. And the Supreme Court held that as long as something is a trademark and is used as a trademark and otherwise follows the statute, the USPTO can't bar registration of immoral or scandalous trademarks or disparaging to other, or trademarks that are disparaging or racist. So those were struck down. So now you can do it, and we've seen a big glut of these types of applications to register trademarks. There's the Bad Motherfucker Wallet, which is actually registered by the film studio that put out Pulp Fiction. That's Skyfucker Underwear. I hope all our streaming services allow me to say these. And Calm the Fuck Down Tea. All of those are recent applications that I've seen with specimens that, in my view, really do indicate the source. So these are actual goods that people are manufacturing with those names, and the trademark office can't say, well, that's an obscene word, I won't do it. I'm going to spare you the applications to register racist and ethnic slurs that have come about since then. But one of the oddest things that happened was the Washington football team had been fighting against people trying to strike down the registration of its ethnic slur team name literally for decades. And with these Supreme Court decisions, it eventually won and kept its registration. And soon after that, they dropped the name entirely and said they're no longer going to use it. They finally bowed down to public pressure. They are now, at least temporarily, called the Washington football team, the least imaginative name they can possibly think of. And if you've been following along, the least protectable name they can probably think of. And in fact, right now they're having their asses handed to them, similar to when they play the New York Giants, by the trademark office and trying to register Washington football team. That's the trademark strategy of a team that has not been to the Super Bowl in over 30 years. I want to be really careful with this. I want to be really careful with this next segment because you're going to see the C word, and that's copyright. This is not a presentation on copyright. Copyright and trademark are different. They have different functions, they have different laws, and they have different rules about who owns them and who gets the rights to them. But you're going to have to know a little bit about copyright, particularly when you're designing logos. And sometimes you come to me and you say, hey, my friend designed this for me. I want to use it. And the first thing I want to know is, who's your friend? Who designed it for you? Who created this? Did you get the rights? And the rights I'm looking for is not the trademark rights. It's the copyright. You're going to have the trademark rights because you're putting it on your things and you're selling it. But copyright doesn't ask who's selling it, who's marketing it. Copyright asks who created it. And the default rule is the person who created your design owns that copyright and can market that. And if you don't have them assign that copyright to you now, years later, they can come back to you and say, where's my money? This is my copyright. You pay up or I'm going to enforce this and take it back. And you're in a big mess. It doesn't happen a lot, but it happens. It happened to Harley Davidson. It happened to Rockefeller Records. Someone came and said, I designed this for you. You never paid me. Kept these companies in courts for years. And they both won. But they won after spending who knows how much money to litigate something where it would have been completely clear if there was just a written assignment. The basketball player Kawhi Leonard designed this one for Nike. This one's a much more complicated dispute where he claims that he created this. He owns the copyright. Nike's using it as a trademark. It became a big mess. Notice I said trademark law doesn't ask who created it. It asks who's marketing it. It also doesn't ask whose idea is it. It really doesn't matter whose idea it was for you to put it on there. The company that markets it and puts it out there is the one that has rights to it, not the person, the employee at the company, and said, I got an idea, I'll call it this. Whose idea doesn't matter. Another quick story. some years ago, a guy had an idea to personalize your credit cards. They wanted your photograph or a photograph of your choice on that credit card so that it's unique to you and that would have something on it that personalizes the things you like to do and put it on the credit card. And he thought it was a great idea. And he went to different credit card companies, sent them letters, tried to get meetings with all of this. And he had an idea and he had a logo associated with it. The logo was My Life, My Card. Went around to everybody. Everybody turned him down. Supposedly he even got in the foot of the door one of them, but nobody took him on. What happened? Okay, nothing, it all fell through. But a few months later, he sees this ad and this ad and this ad. It's American Express using the words My Life, My Card all over the place. So he sued for trademark infringement and he lost. Why did he lose? Because it didn't matter that it was his idea. He wasn't using it as a trademark. The fact that you tried to sell your idea to other people, the fact that you had an idea for credit cards, the fact that you put it on the top of your letterhead, that wasn't enough. Didn't have trademark rights, didn't win. American Express says we never saw it, we never took your idea, but it's not even going to matter under trademark law. They won. You're selling cannabis products, very tricky. I need you to be really careful and listen carefully. And I'm not your attorney. Under federal law, the United States has determined that certain THC products are now decriminalized. They're now legal and you can sell them. Since you can't get trademark protection for a good or service that is illegal, right? Murder Inc., you could register Murder Inc. for a record label, but not for an actual hitman. You can't register a trademark for illegal goods. Now that certain products are no longer illegal that contain THC, you can register trademarks for them. So we've seen a number of these, not just in the marketplace, but these are all specimens that I found on the USPTO database. They applied to register these trademarks for THC goods. They said in their application they use no more than a certain amount of percentage of THC. Be really careful. Pot for smoking is not a good that you can register a trademark for. It's still technically illegal under federal law, even if it's legal in your state. So if you'd apply to register a trademark for a cannabis product for pot that you can smoke or something like that, not only will you not get registered for because the good is illegal, but when you apply to register a trademark, you are declaring under penalty of perjury that you're using this good or that you have a bona fide intent to use this good. So do you really want to put that in a declaration, sign it, and send that to the federal government and say that you're doing that? Be really careful about that. If you have a cannabis product, look, you're going legit. Lots of things you need to do when you're going legit that you didn't really think about before. Now you got to do it. Here's some other stuff you shouldn't. Yeah.
There's a question here. What about registering with the state, like California? Is it worth it?
Oh, excellent question. Some states have their own trademark registration processes. Some. This is very different, by the way, than registering your LLC or your corporation under your name. When you register the LLC or the corporation in your name with your state, that is not a trademark registration at all. You don't even have to use that name as a trademark. But California has a trademark registration. If you can't get it federally registered and you can get it registered within the state, then it might be something that's worth it. Otherwise, most people just don't do it. There's not a lot of added advantages to it. The California trademark system doesn't, for instance, have a searchable database. And I don't even see the point if there's no searchable database. But California did recently make a change in the rule. It used to be you couldn't register something under state law that you couldn't register under federal law. And that meant that you couldn't register your trademark for pot for smoking, for cannabis smoking products in California, even though it was legal in California, because it's not illegal. It's not, the trademark office won't do it. They've recently made changes to that, but check the law first. The only times you would only want to do it with the state is a situation like that where you know, it's not going to be registered under federal law, but it might be under state. Another time is when you know you're like one location. This is my storefront. It is absolutely doesn't touch interstate commerce at all. But honestly, it's not very common. You can talk to a lot of trademark lawyers and they'll tell you they might have never done it or rarely did it. Another thing, if you're a cannabis company, stop doing this. Just, they're going to come after you. The Sour Patch Company, the candy company that owns the rights, is going to come after you for Stony Patch. They're going to come after you if you make something that looks like a Reese's peanut butter cup. Here you can see the Nerds. They sued over this as well. One of these is a cannabis product. One of them is the actual candy. It's hard enough to even see from this picture which it is, which is the point. They'll destroy you. And part of going legit is don't do this anymore. Come up with your own packaging. Come up with your own ideas. These are big companies. They will do what they can to shut you down, and they will probably succeed. Even if you could win, even if you can beat them on the basis that people will see this as a parody, you're never going to get your own trademark protection for parody. Questions?
There isn't one in that. Nope.
Okay, we got a few more minutes, and then I'll take questions at the end. I just want to talk a little bit about trademark considerations that aren't necessarily legal considerations. And you know these yourself because you see them in the news, and I want you to think about them. There's a lot of things you might be able to get away with. You still want to reconsider. This was a company that a guy put out a Hawaiian food restaurant, called it Aloha. The person who started the company had absolutely no Hawaiian roots, no Hawaiian ties, was not native Hawaiian. Angered a lot of people because of the cultural misappropriation, and ultimately had to make changes because of that, because of the public uproar. Also, it turns out that even though most places don't register it, there are a lot of other establishments that call themselves Aloha. It's not very unique. And if you get that kind of registration, you're going to have a hard time enforcing it because you're going to have to keep going after people and risk one of them telling you you don't have real trademark rights. This was the poor Arthur romance novels, who wrote a bunch of romance novels about cocky people and decided to get a registration in the word cocky for romance novels. And she did. But the problem was she used that trademark registration for the word cocky and went after other romance novels. And you never want to anger fans in a niche fiction. You just never want to. They all turned against her. It was pretty unfortunate. She eventually gave up the registration. Apparently, cocky is a really common trope in romance novels. So they got away with it at the trademark office, but they did not get away with it in the market. Was there a question?
No.
Oh, I see a better trademark here. It's the word Cocker Brothers that you see at the top. A Cocker Brothers novel. Assuming that she's the only one that writes about those particular men, that could have been a little better. I talked about uniqueness. This is Premier Limousine. Each of these are not the same. They're all different companies. Whether or not they're arbitrary or fanciful or descriptive trademarks, the point is there's lots of them. And a few years ago, when there was a terrible accident that killed people involving Premier Limousines, each one of these took a business hit from it. Bodega took a big hit. Their thing was they would come to your office and have these snacks out there, and people can purchase them with a card, and they call themselves Bodega, which, again, if you're from the New York area, you'd associate with your local market. And people were very offended by that they were basically taking the name of the market. They got press that said, here's this company that's going to destroy your local bodega or take all its business. People didn't think kindly of that. You may even notice the logo is shaped like a cat, because after the infamous bodega cats that you would ordinarily see in little stores in New York. They could have gotten away with it, but as a PR move, it worked out pretty terribly. My name is Mark Jaffe. I'm partner at Trademark Law. You heard from Elissa, our COO. If you want to know more about trademark law and the other things that we do, copyright law, trade secrets, and other type of business things, visit us on Facebook, visit our website, visit us on Twitter. Through the website, you can schedule consultations. If you had questions that we didn't get to at the end, you can put them on our Trademark Law Twitter account, and we'll see them and may be able to answer them today or tomorrow. I had a lot of fun doing this. Remember, utilize a good strategy that helps build your business, that helps make you money, and doesn't get you into traps. Do we have time for any questions? Or at the end?
Yeah, well, there's only one. Is a comment. It just says the wrestler Sting has beef with ICP about trademarking white face paint. Is it possible to trademark white face paint?
White face paint. Well, really, it would really. Who has a problem with it?
It says the wrestler Sting and ICP. I mentioned the same clown policy problem.
Well, Kiss did. Kiss got trademark protection, the band that is, for the different makeup that was associated with the members of the band. They have that registered. You can look it up. Each and every face, even each and every makeup design on their face. So it is possible. And it's possible there because they were able to convince the trademark office, which you already know, that we associate this with this particular band. And since different people left the band and other people came in, those trademark rights stayed with the band and not the people who was on them. Something that, if you're a band, you really want to negotiate by contract and have it in writing.
Is that
but whether or not the particular wrestler, yeah?
Is that hard to transfer rights if a owner has the trademark instead of business, or a musician has the trademark instead of the band?
Well, with band, yeah. It used long ago, there were more bands that were just owned by an individual or a corporation, right? Bands like the Drifters, and they would just fire people. They fired all the members of the band and then brought Benny King in, right? And then Benny King left, and they brought other singers in. They just kept changing, and it was all Drifters owned by one individual. But they've been fighting about that for decades. Usually we assume, however, that it's the members of the band that have that trademark, and the most important trademark consideration for a group of people, for a partnership like that, or particularly a band, is not just, are we infringing somebody else's? The most important one is who owns it. Who owns those rights? And that is best solved with a contract that says this trademark is owned by these particular people. If any one of them leaves, they're not entitled to perform under that name. And it may set up even more specific things, like you would be allowed to say former member of this band. It's happened dozens of times, dozens of disputes like this, where someone leaves the band or the band breaks up and then they fight over who it is. It's happened with the oldies, like the Drifters and the Platters, all the way up to Color Me Bad, the Commodores. There's just Pink Floyd, the Pixies, dozens of these types of disputes. One of the best ways to make these things certain is to have it written in a contract, which ideally is deferred to.
That looks like it's all of our questions. I just want to state to anybody still viewing or who views this later on YouTube or Facebook that I will go in and check for any additional questions and put them in front of Mark and see if we can get answers for you.
Thank you, Alyssa. Follow us on each of these. Follow my Twitter on Trademark Law and Mark J. King's. When we have other presentations on different areas of law, trademark and copyright and other things that you want to know about your business, we'll put all this information on there. If you were here and you enjoyed this, there's something you liked, something you want to know, we'd love to hear from you. So you can either put it on the comments of any of these streams or on Twitter, Facebook. Thanks, everyone.
Bye.